Most people spend their entire lives managing debt. They make monthly payments on credit cards, car loans, mortgages, student loans, and personal loans. They track their balances and their rates and their payoff dates. But almost nobody ever asks what happens to that debt if they die before it is paid off. And for a significant number of American families, the answer to that question will genuinely surprise them. In most cases, when you die, your debts do not simply disappear. They do not vanish. They do not transfer automatically to your spouse or your children in a simple way. They go through a process called probate, where your estate, meaning everything you own at the time of death, is used to satisfy your outstanding obligations before anything is passed to your heirs, and in specific circumstances involving co-signers, joint accounts, and community property state residency, your debt can become someone else's responsibility in ways that most people never anticipate. Today I am going to walk you through exactly what happens to each type of debt after death, identify the specific scenarios where your debt can pass to a surviving family member, and give you the specific protective actions you can take right now to prevent your debt from becoming your family's financial problem. Before we go further, everything in this video is for educational and informational purposes only. It is not legal advice, financial advice, or estate planning advice. Estate and debt laws vary significantly by state, and individual circumstances vary widely. I am not a licensed attorney or financial advisor. Please consult a qualified estate planning attorney or financial professional for advice specific to your situation. With that said, let us get into the specifics. Let me start with the foundational concept because everything else builds on it. When you die, your assets and liabilities become what is called your estate. Your estate goes through a legal process called probate in most states, where a court oversees the distribution of your assets. During probate, your estate's assets are first used to pay off your outstanding debts in a specific legal priority order. Only after your debts and final expenses are satisfied does anything remaining pass to your heirs. This means if you die with $150,000 in assets and $80,000 in debt, your heirs do not inherit $150,000 and walk away from the $80,000. Your estate pays the $80,000 first. Your heirs receive approximately $70,000 minus final expenses and probate costs. If your debts exceed your assets, your estate is considered insolvent, and your heirs generally receive nothing from that estate, though in most circumstances they are also not personally responsible for the excess debt. The key word there is generally, and I am going to explain the exceptions. Now here is where it gets significantly more complex, because the simple estate picture changes dramatically depending on the type of debt and the structure of the account. Credit card debt held in your name only, meaning a sole account with no authorized users who signed a credit agreement, is generally an unsecured debt of your estate. The credit card company has a claim against your estate during probate. If your estate has sufficient assets, the debt is paid. If your estate is insolvent, the credit card company typically receives nothing or a fraction of the balance. Crucially, your surviving spouse or children are generally not personally responsible for paying a credit card debt that was in your name only, unless they were co-signers on the account. Here is where the first major exception appears. A co-signer is not simply an authorized user. An authorized user is someone who can use the account but has not signed the credit agreement. A co-signer or joint account holder has signed the credit agreement and is equally legally responsible for the debt. If you die with a co-signed credit card balance, a co-signed auto loan, a co-signed personal loan, or a co-signed student loan, the co-signer, whether a spouse, parent, sibling, or friend, is fully responsible for the remaining balance. the lender can and will pursue the cosigner for the full outstanding amount. This catches families completely off guard. A parent who co-signed their child's student loan or car loan, a spouse who co-signed a credit card opened during the marriage, a sibling who helped a family member get approved for a personal loan. If the primary borrower dies, the cosigner inherits the debt in full. This is not a gray area. It is clearly documented in every co-signed credit agreement. The second major exception involves community property states. 9 states in the United States use a legal framework called community property, meaning that most assets and debts acquired during a marriage are considered jointly owned by both spouses, regardless of whose name they are in. Those states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Alaska has an opt-in community property system. In community property states, a debt incurred by one spouse during the marriage is typically considered a debt of both spouses, even if the other spouse never signed anything. If one spouse dies with credit card debt, medical debt, or other obligations incurred during the marriage in a community property state, the surviving spouse may be responsible for that debt, even though their name was never on the account. The rules vary by state and by the specific type of debt, which is why this area requires specific legal guidance based on your state of residence. The third major exception involves mortgages and secured debts. A mortgage is a secured debt, meaning the lender holds a lien on the property. When the borrower dies, the debt does not disappear, and neither does the lien. If a surviving spouse or heir wants to keep the property, they must continue making mortgage payments or refinance the loan into their own name. If no one continues making payments, the lender can foreclose regardless of the emotional circumstances. The home does not transfer to an heir free and clear simply because the original borrower died. Under federal law, specifically the Garn-Saint-Germain Depository Institutions Act, lenders cannot automatically accelerate a mortgage when a borrower dies and the home transfers to a family member. This gives heirs time to decide whether to keep the property and assume the payments or sell and pay off the remaining balance. But the mortgage obligation itself does not end at death. The fourth scenario involves joint bank accounts and beneficiary designations. Bank accounts, retirement accounts, and life insurance policies that have joint account holders or named beneficiaries pass directly to those beneficiaries outside of probate. A joint bank account transfers immediately to the surviving joint account holder. A 401k or IRA with a named beneficiary transfers directly to that beneficiary. A life insurance policy with a named beneficiary pays directly to that person. This is both a protection mechanism and a planning tool. Assets that pass directly through beneficiary designations are generally not subject to estate creditors in the same way that probate assets are. Properly structuring your accounts with beneficiary designations and joint ownership can protect certain assets from estate claims. Stay with me because this next section is the one that actually protects your family. I am going to give you the specific actions that separate the families who are financially prepared from the families who discover these rules in the worst possible moment. Here is your protection plan. 5 specific actions. First, review every debt you currently carry and identify whether any of them have cosigners. Credit cards, auto loans, student loans, personal loans. For each cosigned debt, understand that the cosigner will be fully responsible if you die before the debt is paid off. If your cosigner is a parent or sibling who could not afford to absorb that obligation, this is a significant risk that adequate life insurance can address. Second, determine whether you live in a community property state. If you do, and you have debt incurred during your marriage, speak with an estate planning attorney about how your state's community property rules apply to your specific situation. The rules are state-specific and the stakes are significant. Third, review your life insurance coverage in the context of your total debt load. The purpose of life insurance in the context of estate planning is to ensure that your estate or your designated beneficiaries have sufficient funds to satisfy your obligations without leaving family members financially burdened. A simple rule of thumb from financial planners is that your life insurance coverage should at minimum cover your outstanding mortgage balance, any co-signed debts, and several years of income replacement for dependents. Fourth, verify and update your beneficiary designations on all accounts. 401k plans, IRA accounts, life insurance policies, and bank accounts with payable on death designations. Assets with current, correct beneficiary designations passed directly outside of probate are generally protected from estate creditors in most states and transfer immediately without the delays of the court process. An outdated beneficiary designation, such as one that names a deceased person or an ex-spouse, can create serious complications. Fifth, create or update a basic estate plan. At a minimum, this means a will, a durable power of attorney, and a healthcare directive. An estate planning attorney can typically prepare these documents for between $500 and $2,000, depending on the complexity of your situation. This is significantly less than the cost of court intervention or family disputes that arise from having no plan. For free tools, the free estate planning checklist at nolo.com, the free beneficiary review worksheet at fidelity.com, and your state's specific probate and community property rules through your state's Attorney General website, or a consultation with a local estate planning attorney. Before we close, one final reminder. Everything in this video is for educational purposes only. Estate law is highly state-specific, and the scenarios described are generalizations. Co-signer obligations, community property rules, and estate creditor protections all vary significantly by state and individual circumstance. Please consult a qualified estate planning attorney for guidance specific to your situation. Here is what I want you to take from this video. Debt does not automatically disappear when you die. In specific circumstances, it can become someone else's problem. Whether that someone else is a co-signer who trusted you, a surviving spouse in a community property state, or an heir who wanted to keep the family home. The rules exist. Most people never know about them until they are living the consequences. You now know. The question is whether you act on that knowledge before it matters. If this gave you clarity on something most people only discover at the worst possible time, subscribe right now. We release financial investigations exactly like this 3 times every single week, all free, and I want to hear from you. Before watching this, did you know that debt could pass to a co-signer or surviving spouse after death? Comment yes or no below. I read every comment. I will see you in the next one.